Welcome. In this explainer, we're going to break down one of the most fundamental documents in all of business law, the Memorandum of Association, or as you'll often hear it called, the MOA.
So what is an MOA? Well, a great way to think about it is like the architectural blueprint for a company. It's the foundational document that sets out its identity, its purpose, and, this is key, the absolute limits of its power. In short, it dictates everything the company can and cannot do.
All right, here's what we've got on tap. We'll start with the why the MOA is so essential. Then we're going to dissect its anatomy, piece by piece. After that, we'll get into what happens when a company steps outside its own legal boundaries.
So, first up, the company's essential charter. At its core, this is all about creating clear, public boundaries for everything the company does.
The MOA basically lays out the objects of the company, its purpose, and the scope of its activities. And here's a crucial point. It's a public document. That means anyone, whether you're a potential investor or just a supplier, is presumed by law to have read it and to understand the company's official powers.
So as you can see, the MOA really acts as a shield, protecting all the key stakeholders. For shareholders, it's a guarantee that their money is being used for the agreed-upon purpose. For creditors and partners, it provides a clear, public record of what the company is legally allowed to do.
Okay, so what's actually inside this all-important document? Well, every MOA is built around 6 key clauses that together paint a complete picture of the company.
These 6 clauses are mandatory. You've got the name clause, registered office, object, liability, capital, and the association clause. Each one defines a really critical aspect of the company's identity and its legal framework. Let's break them down. The first 3 clauses are basically the who, where, and what. The name clause is simple. The company name must end with limited or private limited. The registered office clause just tells you which state the office is located in, but the object clause, now that one's a big deal. It defines the very purpose of the company and all of its business activities. This clause is what draws the line in the sand.
Next up, we have the clauses that deal with the money, or the how much and who. The liability clause states if the member's liability is limited by shares or by a guarantee. The capital clause details the authorized share capital. And finally, the association clause is where the initial subscribers formally confirm their intention to form the company. Now, not all companies are the same, right? So the law provides different templates or tables for the MOA depending on the company's structure. As you can see, whether it's a company limited by shares or one limited by guarantee or even an unlimited company, there's a specific form of MOA it has to follow. So what happens when a company ignores its own blueprint? What if it acts beyond its own boundaries? Well, this brings us to a critical legal principle known as the Doctrine of Ultra Vires.
Ultra vires, it's a Latin term, and it literally means beyond their powers. It applies to any act or contract made by the company that goes beyond the powers stated in its object clause. And the consequence is severe. The act is considered wholly void, not just voidable, but void. In the eyes of the law, it's as if it never happened.
Now, this slide highlights an absolutely critical distinction. If an act is ultra vires the company, meaning it's outside the scope of the MOA, it's void, period. It can't be fixed. But if an act is just ultra vires the directors, meaning the company could do it, but the directors weren't authorized, well, that's a different story. The shareholders can actually vote to approve it and make it valid. Okay, theory is great, but let's see how this doctrine works in the real world by looking at the landmark case that established it all. Ashbury Railway Carriage versus Richer. So the Ashbury Company's MOA was very specific. Their business was to make, sell, and lend railway carriages and to work as mechanical engineers and general contractors in that field. Pretty clear, right? It's all about railways. But then the company's directors made a deal to finance the construction of a railway in Belgium. Notice the shift. They weren't building railway parts. They were acting like a bank. This was a whole different ballgame. So the big question was, could financing a railway line be considered part of their business as general contractors? The company argued it could, and the shareholders even voted to ratify the whole deal. But was that enough to make it legal? Well, the court's decision was definitive. They said the contract was null and void. The judges ruled that the term general contractors had to be interpreted in the context of the company's main business, which was mechanical engineering.
Since financing a railway wasn't mechanical engineering, the contract was deemed ultra vires and therefore totally void.
This case really cemented the serious consequences of an ultra vires act, which are strict and pretty unforgiving. So let's summarize the key rules here. This is the harsh reality. A company can't be sued on an ultra vires deal, but it also can't sue anyone else on it either. And as we saw with Ashbury, even with unanimous shareholder approval, you can't breathe life into something that was void from the very beginning. It's a legal nothing. So if you remember one thing, make it this distinction. The boundary is the MOA itself. If the company crosses that line, the act is void. If a director crosses a line but stays within the company's overall powers, the shareholders can fix it. So where does that leave us today? Well, while the doctrine of ultra vires is still on the books, its teeth aren't quite as sharp. That's because modern company law makes it much easier for a company to simply amend its MOA. With a special resolution, a company can alter its object clause, effectively just moving the goalposts.
And that leaves us with a final thought. In today's fast-changing business world, where companies need to pivot and evolve constantly, does this 150-year-old legal boundary still protect investors, or does it just get in the way of modern innovation? Something to think about. Thanks for watching.